My name is Ellie Fox. I am the Associate Director of 92NY Talks Department. So nice to see such a full room. This is lovely in our brand new Warburg Lounge. If you haven't been here yet, it's beautifully renovated, as you can tell. It is my pleasure to present tonight's event, Checks and Balances. What limits are there on presidential power? We are doing this in collaboration with Folks, the Forum on Life, Culture, and Society. This program is also part of the Newmark Civic Life series and is brought to you through a generous gift from Craig Newmark Philanthropies. Within this series, we're raising awareness for Take 9, a public service campaign created to help individuals against cyber threats by taking a 9-second pause before you click, download, or share. Okay, so tonight we will discuss the unprecedented expansion of President Trump's executive authority. Though he's not the first president to flex presidential power with frequency, he has generated more challenges to the reach of his constitutional authority than any other president before him. We have a 92NY all-star panel of experts to break this all down for us, alongside our moderator, Thane Rosenbaum, who is the founder and creative director of Folks, and a longtime friend of 92NY, who has moderated events on our stage for just about 30 years. Yeah, yes. Just quickly, before we get started, please note that we will have time for your questions. Our ushers are going to be distributing cards, so please ask a question. If you are viewing on the live stream, hello out there. You can ask a question too, submit it in the chat. Thank you all so much for being here and for supporting our programs. And with that, please join me in welcoming Thane and our brilliant panel.
Hi, everybody, and hi, everybody at home. Donald Trump began his second term with a flourish. He had already issued 200 and some odd executive orders during his first 4 years, and he has already issued another 200 and something, and right now he's totaled at 460. That's a lot. And he's saying, you know, I received a mandate. There are things I wanted to do. The people spoke. I wanted to do something on immigration. I wanted to flex more power in foreign policy. I wanted to close the borders. I wanted to end birthright citizenship. I wanted to do something about campuses, and I even have an enemies list of law firms that I want to go after. And how do you do that? And executive orders is a way to not require congressional authority. If you don't have the votes, you can go by way of an executive order. But yes, it is unprecedented for he's not only still 3 more years with 460, but I just took some, if you're scoring at home, you might be interested to know. George W. Bush, Michael's old boss, 291 over 8 years. Obama, 276 over 8 years. Clinton, 364. Now here's the interesting part. Truman, 907. A Democrat. And here's the one that might surprise you and may not surprise you. FDR, right? 3 terms, lots of time to do stuff. 3,726. There's no way that he could catch him. Although, you know, Trump, he will want to. I could get him. So there's a lot of unilateral action that he's undertaken. And if the founding fathers were sitting in the front row and they saw this distinguished group of scholars, who I will introduce in a moment, and they said, well, I don't see what this is an obvious point. We fought against the King George III. That was a revolution. We don't even want an imperial presidency. You know, we don't want any monarchs. You know, we don't want any expansion of presidential authority. Or would they say, well, somebody's got to make these decisions. Otherwise, there's just impasse. You can't have a king, but you also can't have too many cooks. And somebody has an agenda, and we're a democratic republic, and he won an election. To discuss this, we have 3 truly all-star people. My friend Melissa Murray, who is a law professor at NYU. She is a rock star podcaster. She has a new book coming out in, I think, May or June? May. Ready for this? Talk about how the 92Y, NY, and Folks gives you exactly what you want. Her book's title is U.S. Constitution, a comprehensive and annotated guide for the modern reader. She's the right person for that. Melissa Murray. He was a former federal district judge here in New York, in the Southern District of New York, and the Attorney General for George W. Bush, Michael Mukasey. And this guy, you may know, by the way, these are all friends, and we've done events like this before. I try not to keep enemies on stage. We just do the friends. Neil Katyal, so many things to say. Over 50 Supreme Court cases he's argued. He was an acting Solicitor General for the United States. That meant that he was representing the United States before the Supreme Court. He's so young, he may actually, I don't know what the number is for you to go to, he may end up with the most Supreme Court arguments in history. He's already beat Thurgood Marshall, which is pretty amazing. He is a law professor at Georgetown Law Center. He's a best-selling author. And he's also an erstwhile actor. Yes, it's true. He's been on Billions and on House of Cards. And in an act of casting against type, he played himself. They wanted someone to play Neil Katyal, and they decided to get Neil Katyal. Neil Katyal. All right, speaking of Founding Fathers, Alexander Hamilton, by the way, they made a musical about him. I don't think it's going to hit at all. So he's now not just a Founding Fathers, but he's a hip-hop hero. And he's clearly one of the authors of the Constitution. Madison gets most of the credit, but the Federalist Papers, he's in it. And in Federalist Papers number 70, he wrote that he thought the executive powers of the president, that what we want is a strong and energetic executive. That's an interesting choice of words. Strong and energetic. That means not sleepy. We're expecting you to do stuff. We expect you to function like a chief executive. And so the question here is, in Article 2 of the Constitution, and this is obviously going to be in Melissa's book, it's very vague about what does it mean, what does executive mean? It means the president has the ability to exercise executive authority over things that the executive does. I mean, that's kind of what it says, which doesn't say anything, really. So I wonder whether there is an argument to say, is this unprecedented? We know FDR had an agenda. He won an election, Trump. And Alexander Hamilton, who was really good friends with George Washington, anticipated someone like George Washington who would be energetic. Oh, I forgot to tell you. Ready for this one? George Washington, 8. That means 1 every year that he was president. And Lincoln, I think, was something like 28 or something, 40. So anyway, energetic executive. Is Trump way off? Is this an example of a guy out of control?
So thank you so much for having me. It's great to be here. I will say your first point about the Founding Fathers looking at this stage and the first question they would ask would be about the Constitution. I'm not sure that would be the first question they would ask if they saw this panel arrayed here.
That's true.
I don't think this panel is exactly what they had in mind.
They would say, why are there 2 Jews on stage?
I think the woman might also give them pause.
Oh, yes.
But thank you.
Liver? Yeah. Oh, they might do that too, Melissa.
So just to put that out there, when they were framing the Constitution, a number of things were top of mind. They had just come out of the Revolutionary War, the colonial experience. So much of what you see in the Constitution is literally the result of trauma. I mean, if you think about it, now it is a trauma-informed document. So much of the Constitution responds to things that were done to them by the British Crown and the British Parliament. Article 1 is the first thing they get to. It's all about Congress. It is very clear about limiting Congress to specific powers because there was a parliament that had basically wreaked havoc on their lives. They were less concerned with the prospect of an executive. Obviously, they had real grievances with the king. George Washington talked about it. Thomas Jefferson enumerated them in the Declaration of Independence. So they were very worried about the prospect of a monarch that had too much power, but they were really worried about Congress having too much power. And they recognize that.
And is that why they started with Article 1 with Congress?
They start with Article 1 with Congress, and they make Congress fettered in a lot of ways. Congress can't just do things. It has to be consensus-based. There are lots of different checks, even within Congress, on what they can do. And that by itself was a structural limitation on a legislature run amok. The executive occupied less of their time. They were less clear about what the executive power involved and what it didn't. Although I will say they also made clear that the executive could be subject to impeachment. So they were definitely contemplating the prospect of an executive that would engage in misconduct and wrongdoing.
Yeah, but then they didn't tell us what high crimes and misdemeanors were.
Well, I mean, they didn't say a lot of things about lots of parts of the Constitution. So much of this, again, is open to being construed. Enter the judicial department with the province and duty to say what the law is. But the whole question of the executive and this idea that this person had to be nimble was a big part of it, being able to respond to certain things. And again, they just came through the Revolutionary War. They were being governed by the Articles of Confederation, which was literally like, a pinky swear pact between states to sort of loosely govern themselves. They wanted to be able to maintain the sovereignty of all of the states, but also run a government. And it turned out you just can't do that. You can't have it both ways. If you want to have a national government, you've got to give up some things and you have to centralize power.
They end up with one executive, and they have the idea of checks and balances, and they have the idea of separation of powers. But are you sure they thought that they truly are co-equal branches of government, that they're each 33.3% in charge? Or, and I want to get Michael involved because I think you worked for a energetic executive for 8 years. You weren't there for 8 years, but he did stuff, George W. Bush, some things that people didn't like. And you could say, look, was he nimble? Did people in the cabinet or in the Justice Department think that you were constrained by co-equality? Or did you say, we're in a war after 9/11. We get to do what we want now. We get to run the table. Because it certainly looked that way for some of the ways, although Neil argued the Hampton case, and that sort of put a check on that unfettered power. And before Mike answers that, I want to just excuse the fact that Neil, he's going to leave a little early. And the reason for that is because he argued the Tariffs case before the Supreme Court. And that case is probably, there's a likelihood, I think a 25% likelihood, they say higher, that you will see it tomorrow at 10:30. So how cool are you that you are in this room with the guy that argued the case and he's racing to Newark to get home, because that's what the 92nd Street Y and folks can do. So we're going to lose him at some point, so we're going to get to him in a second. But Mike, why don't we just jump in here a little about the powers of the presidency and the energy?
He always, not always, but on several occasions looked to the Justice Department as to whether he could do stuff. And the office at the Justice Department that told him whether he could do stuff was an office called the Office of Legal Counsel, which doesn't get a whole lot of publicity, but is really kind of the defining legal authority for not only the President and the Justice Department, but for most of the agencies.
Yeah, but it doesn't seem like Trump is
discomfort.
listening to that, right?
Well, I don't know whether he's listening to it or not. I don't know who he put in place. I don't know offhand who he put in place to head the Office of Legal Counsel. My guess it was somebody who was probably friendly to what he wants to do.
Well, remember, your job when Donald Trump took over the White House was given to Jeff Sessions. And then when the Russiagate started, he wanted Jeff Sessions to just get rid of it. And Jeff Sessions said, I'm not your lawyer. Right? He said, I don't work for you. I work for the Constitution. And he got rid of Jeff Sessions. And so you can see Caroline Leavitt, Pam Bondi, right, is an example of someone who's going, I'm not Jeff Sessions, right? I'm functioning in a kind of surrogate way.
In a way, my predecessor had the same problem. I mean, he at one point said he was somebody who had been White House counsel.
Remind us who that was?
Gonzalez.
Oh, right, Antonio Gonzalez.
And he had the misfortune to say at one point that he wore two hats, one as a member of the administration and one as the Attorney General.
And that must have sounded like strange to people like law professors in particular. What do you mean you weren't?
It sounded strange to Dianne Feinstein, which was more important than law professors. And he faced a good deal of trouble because of that.
So, Neil, now that I set everyone up with the tariffs case, let's talk about them. You argued this before the Supreme Court. You represent wine importers. Oh, yes, go ahead.
Just one more point I wanted to add about the trauma that
Melissa,
that expresses itself in the Constitution. Part of the trauma was the survival under the Articles of Confederation, and it was free play. And each of the states regarded themselves as independent, and that's why the Article 1 begins with all legislative powers herein referred to, or herein listed. And they're very specific about what legislative powers there are. Article 2 says the executive power. It doesn't say all except a little bit of the executive power. It doesn't say most of the executive power. It says the executive power.
And that leads to the ambiguity. The tariffs case. Neil represents a number of small businesses, but it's oftentimes referred to as the winemakers or the wine importers. They were objecting to the tariffs. Donald Trump's argument is there's a statute, the International Emergency Economic, what is it? What is it called? Emergency Economic Powers Act, right? He uses a statute that had never been used in this way. Usually dealt with sanctioning other governments or freezing assets. Instead, he's saying, well, this act, International Emergency Economic Powers Act, has the word emergency in it, and I ran on the idea that the trade deficit is an economic emergency, and there's an emergency, and I want to deal with the tariffs this way. And he can't because you argued.
Yes, so I'm going to deal with tariffs, but just a couple of things first on what's been said. First, yes, the Constitution's the product of trauma, but it is a magnificent document. I mean, think
trauma can make great
things. Absolutely. But I think it's important to understand, yes, there is this stuff about a strong executive for all the reasons the judge has identified coming out of the Articles of Confederation. But it is also one that is checks and balances laced into the document. And, Federalist 51, Madison lays it out very cleanly. People aren't angels, and so you need government, and you need government to be divided to check each other. And what they didn't anticipate fully is the rise of political parties that would be so blind that they would just do the president's bidding no matter what. And that's why you see, where is Congress today? I mean, it is AWOL. And it is, and so the founders, for all their vision and all their genius, I don't think quite anticipated this. And that's why we have some of the problems we have. And with respect to Judge Mukasey, I do want to say, I think that when we think about what's happened in the Trump presidency so far, yes, there are constitutional problems, but there are also very much departures from norms. And those aren't necessarily unconstitutional. When you indict John Bolton and James Comey and investigate Jerome Powell and Letitia James and Don Lemon and 6 members of Congress, there isn't necessarily something unconstitutional about that. There might be, but it is such a departure from the norms. I saw it today, and I thought it was AI. I saw on, in social media, a picture of the Justice Department, the beloved place where we worked at 10th and Constitution, outside with a huge banner of President Trump in front of the Justice Department. That is not the Justice Department that I knew. The Justice Department I knew, which I started the day that Judge Mukasey left, January 20th, and he put in place Mark Phillip to be the acting Attorney General, the deputy. And Mark Phillip ran the department with the Obama administration for a few weeks while the person was being confirmed by Attorney General Holder. And Mark Phillip ran it in a nonpartisan way. He treated us as respectfully and incredibly as possible. The judge's 2 solicitors general who served before him, under him, both met with me multiple times in the weeks before to tell me what's at issue in the office, how to run it, what the big issues were, and approached it in a totally nonpartisan way. So much so that I didn't change a single position that the Bush administration took when I came into office. That's the Justice Department, non-political. My staff, 16 attorneys, I thought they were all going to be kind of right-wing firebrands. No, there were 13 of them that were Democrats, actually, in this office. And that's the way the Justice Department is.
You're saying during the Bush administration?
Yes.
Right.
Career, non-political, and during Obama and during Biden. Now you have an attorney general who is insisting on loyalty tests to be a prosecutor in any of the 94 offices. The question in the interview is, tell me which executive orders of the president do you want to enforce the most, and things like that. So I think that there's the norms question is separate from the constitutional one, but very important. With respect to tariffs, okay. So yes, there's this 1977 law, IEPA, which says in an emergency, the president has the power to have all sorts of things. And one of the things it says is regulate importation. Nobody for 50 years thought this meant tariffs. They thought it meant blockades and things like that, because tariffs are fundamentally different. You go back to the founding, you think about the Boston Tea Party, tariffs are taxes on the American people that we're paying them. And the founders said in Article 1, Section 8, that power resides in Congress and only in Congress. Indeed, it's the first enumerated set of powers Congress has in Article 1, Section 8, the power to tariff. The president basically said, I can do this, even though no president read it that way. He said, I can do this. We're in an emergency. Now, if you want to know whether Judge Mukasey's prediction or question about, who is this person running the Office of Legal Counsel at the Justice Department, are they telling the president, are they advising the president? Well, this law says, this 1977 law says, in order to trigger it, you've got to show an unusual and extraordinary emergency, okay? The president's executive order on tariffs says 9 times they have been persistent and common for the last 50 years. So the exact opposite of what the statute requires, which is a good tell that the Office of Legal Counsel is either not being consulted or asleep at the switch.
Did the Supreme Court see this?
So the Supreme Court did ask a few questions about that, but honestly, winning on something like that is very difficult because there's such deference to what is an emergency and so on. So most of the focus, at least for our time there, was focused on the question, what does regulate importation mean? Does it really give the president the power to tariff the American people? If so, then the president could, as we said, declare an emergency, a future Democratic president, a climate emergency, and raise tariffs 1,000% on every product from Saudi Arabia, oil or not. There's nowhere for that to end. I think that the argument went well in the Supreme Court. We'll have to see. It's under consideration right now, and we may know, as I say, tomorrow, as early as 10 a.m. tomorrow. I do think it's an important case on whether or not the president does have some checks and balances. Are the courts going to stand up? And this is one that was a truly bipartisan case. I mean, Judge Mukasey actually signed a brief on our side in that case, along with many, many other respected members of the legal establishment.
The independent agency issue. Donald Trump has terminated, fired, removed from office a number of people in independent agencies, I think FCC, FTC, National Labor Relations Board. Now there's also what he wants to do in the Federal Reserve. So those are, and so the question is, well, he would say, well, if you're an independent agency, yeah, you're an independent, but you're in the executive branch, and I'm the head of the executive branch. And if you were in the executive branch, you work for me. And if I want to get rid of you, even if I don't have cause, and if there's no sign of misconduct, I just want you gone. Now, that's an example. I mean, how do you...
Interestingly, there are 2 cases, one involving the FTC,
right,
Slaughter, the other involving the Fed,
right,
Cook. Cook is not Slaughter.
Right.
They've changed their view. They initially claimed, as you said, that they had the right to, because somebody works for the executive, he is the head of the executive, therefore he has the right to terminate them because they are in essence exercising his power by delegation. They tried that with Cook, and there was dictum in an opinion by the Supreme Court that said we think the Fed is different, largely because they do some things that are not executive, and they switched their basis to cause. The cause being supposedly misstating the value of
a house,
misstating the value of the house, or misstating that
mortgage fraud,
principal residence, whereas it wasn't. I think she corrected it later on, didn't she?
She did.
Yeah, but also the argument is this was a house and a tax return that preceded her term.
It preceded her term.
It had nothing to do
before she held office.
Right.
But that's what they're arguing in Cook.
So you're saying you think that it's possible the Supreme Court ultimately could rule in favor of Cook,
absolutely,
even though not in favor of the general principle of the other agencies, treating the Federal Reserve differently. Melissa?
Well, so first of all, these independent agencies are structured by Congress. They're created by Congress. They're meant to be independent for a particular purpose because the work that they do should not be swayed by political whims. So they are purposely structured by Congress to be insulated from partisanship. They have bipartisan membership on their boards. It is the reason why there are limits that Congress imposes on their ability to be removed by the president. And to be very clear, this president wants to be able to control the entire executive branch and to prosecute whatever agenda he has for the work that it does. And the fact of individuals within these agencies who may object to that agenda is an impediment, and he's moving to eliminate those impediments. Rebecca Slaughter, who is the commissioner of the FTC, who was removed, and the Supreme Court allowed her removal on the shadow docket. We should talk about the shadow. We'll get to that. Rebecca Slaughter was part of a body that was literally suing organizations like Amazon and Meta and Facebook and Twitter and TikTok for consumer issues, all kinds of things. These are the same people standing behind the president at the inauguration. There's a reason why
they paid for it.
Well, there's a reason they're supporting him, and there's a reason that this is part of his agenda, and there's a reason why Becca Slaughter doesn't have a job now. Lisa Cook's job is an entirely different thing. You're right that the Supreme Court said earlier in Selah Law, a case from 2019, that the Fed is different. They didn't exactly articulate why the Fed is different. There were words.
Well, different in the sense that it requires its independence.
Different in the sense that the justices have retirement accounts. That's what makes the Fed different. That messing with the Fed has the potential to completely blow the economy, and even the justices recognize that.
Trump.
So I'm in some of these cases.
I think it goes a bit far. I really do. The Fed does things that are not executive.
Fully understand that, but this court has never respected those distinctions in independent agencies. What they do, I think, respect is the fact that the Fed is so inextricably linked to a proper and functioning economy.
I think once you go down the judge's path, though, I agree with you descriptively. I think this is where it's going to come out, that Slaughter loses, but that Cook wins because the Fed is different. But I think Professor Murray's right that it's very hard to distinguish the Fed from, for example, one of my clients, the head of the Merit Systems Protection Board, which is, I think the Fed is far more executive in nature than the head of the Merit Systems Protection Board. The other thing I'd say about these cases, though, there's a bigger thing at issue. It's not just the leadership and in these agencies. It's also the career staff. To me, the great thing about working at the Justice Department was that I had a totally bipartisan staff of people who were experts in all sorts of nooks and crannies of the federal government. And I'd often come in with an impulse, and it might have even been an ideological one, and they would tell me why I was wrong. And that happened to me every week. I mean, and it was the best part of the job, honestly, because that's what yields good decision making. And when you've got a president who is bent on trying to fire all the career staff, forget about just the heads, but all the career staffs of these agencies and replace it with loyalists, you do really have the problem that the 1883 Pendleton Act was all about, which is trying to get a true civil service that's nonpartisan, full of experts.
And make better
we're
decisions.
Giving that up.
And the verticality of his reach I think is unprecedented. And we could go back to the spoils system that was supposedly eliminated.
Boss tweet.
Yeah.
Boss tweet, New Yorkers. Do you think that Trump versus the United States, from 2 terms of the Supreme Court cases, not last term, the term before, this is the one that argued that the president has presumptive immunity for official acts, and even if it's official acts, even the outer contours of those acts, if it's part of within the scope of his responsibility, there's no criminal responsibility. So the argument is, did he get emboldened by that? Do you think that Supreme Court decision had an effect on him, or it wouldn't have mattered? He would have done this anyway. Because you get a sense, and I know that Melissa, who we'll talk later about her recent law review article that just is coming out in Northwestern Law Review, but the idea that he, in his defiance of lower court decisions, he seems to think that he will win before the Supreme Court most of the time. So I can just ignore like the judge that said, don't send off the 250 Venezuelans to El Salvador. Don't send them off. And if you send them on a plane, send them back. And he said, nah. And it's perhaps because he thinks the Supreme Court would never make me do that.
Well, I don't read minds. And if I did, I wouldn't start with his. But I don't think it emboldened him with respect to acts like that, which he has lost consistently on in the lower courts, despite his, or maybe because in part of his abuse of lower court judges who render those decisions. And there are 4 cases coming up to the Supreme Court that he could conceivably lose.
Right. Tariffs
being one of them. Arrests under the criminal alien statute.
Alien Enemies Act.
Right.
We're about to talk about that.
Yeah. And
Birthright Citizenship.
Birthright Citizenship, of course.
And the firing.
Those
are the 4.
Those are the 4. And interestingly, in an exchange in the Birthright Citizenship case, 5 separate justices asked the solicitor, each in different ways, whether the administration would respect the decision of the court. I don't know of that ever happening, but 5 times he answered yes, they would. And in fact, they put in I've got it here someplace. They put in a footnote that the Solicitor General represented that the government will respect both the judgments, i.e. the outcome of the case, and the opinions of this court, which means the rationale for reaching that outcome. That, I think, is unprecedented in Supreme Court history. I don't know whether, I assume that Sauer and the Solicitor General anticipated that question and that he had clearance from the White House to give that answer. Now, whether it's going to hold for after the bad news comes in is something else again. But that is an unprecedented representation.
I just want to make sure that the room and the people at home know what we're talking. The Birthright Citizenship case is one of the executive orders that said if you are a child of someone who is here illegally, or even if you're here, I think, on a temporary visa, you do not get automatic citizenship for your child. That the 14th Amendment's Birthright Citizenship clause was established. Trump keeps saying this. It's for the children of former slaves. He keeps saying for children. He seems to ignore that, 1898, there was a Chinese person who was born here, and then he went to China, came back, and then the Supreme Court ultimately said, he's a citizen, he was born here. But Donald Trump has decided to say, well, it's really the 14th Amendment. That comes out of, that's essentially a Reconstruction Amendment, and it's only for former slaves. So the argument there is he might not care, right, what the Supreme Court said.
These are 2 different cases, though. So the case to which you're referring is now pending before the court, and they're going to hear oral argument. That's on the merits of whether Section 1 of the 14th Amendment, which confers birthright citizenship, says what it says. And I don't know, I can read, I think it says what it says. The case to which Judge McCasey is referring is about that executive order rescinding birthright citizenship, but it's about a narrower procedural question as to whether or not district courts can issue nationwide injunctions.
Well, that's from last year.
Right, but this is where the footnote
right. I know.
was.
I just want to make
so
sure.
Just to be clear.
Yeah, to be clear, that's from last year's
But
decision.
the footnote encompasses much more.
For sure, but I think the most unprecedented part of the footnote is that John Sauer refused to say he would obey the lower federal courts. He was pressed repeatedly at oral argument on that question. He refused to say he would respect the decisions of district courts or intermediate appellate courts. He did say, I guess grudgingly, I don't know, that he would respect the United States Supreme Court. But that's not the whole judiciary.
The answers didn't sound grudging. And yes, they have played fast and loose with the decisions of lower courts, not just not respecting them, but persisting in the conduct that they were engaged in, but changing what the legal basis is for it. Judge says, you're not allowed to do that because you're relying on X. And they continue to do that and say, no, now we're relying on Y.
But that's such a huge breach. This is what Neil is talking about. Like, you would never have seen Neil or Elena Kagan or even Thurgood Marshall, a Solicitor General, doing anything like that.
Right. Or even me. I argued one case.
So well. It was so good.
He's trying to catch up to Neil.
I'm 1 for 1.
Before we move on, I just do want to say a word about Trump versus United States.
Good.
The decision that I think, I'm a fan of the Chief Justice, but it was, I think, his lowest moment. The idea that saying that the Constitution confers an immunity on the president for his actions. I do think it's a dangerous, reckless decision. For someone like me, who's an originalist, I don't see that anywhere in the original understanding of the Constitution. Indeed, the majority didn't even try and put it there. And I do think that decision will not live. I think that decision will be overturned because it is so fundamentally un-American. It is a betrayal of what I started with, the constitutional vision, divided power.
Interestingly, that even the impeachment clause, which provides for the removal of the president, says that criminal acts, which may be the subject of impeachment, can be punished in the criminal courts after he's removed.
Right, as if it contemplates the possibility of...
Correct.
To remember again, so there was essentially 2 birthright citizenship cases. The first one is sort of a misnomer from last year because it really wasn't about birthright citizenship. It was just about one judge imposing a nationwide injunction on this new law that Trump tried to implement through this executive order. And so the Supreme Court essentially ruled, and that's what the judge is reading from the opinion, that it said that no judge has that power to be able to create nationwide injunctions. I want to talk a little about foreign affairs and executive authority, because so many of the cases and executive orders, if you think about it, Alien Enemies Act, deportation of Venezuelans who are here allegedly gang members, the kidnapping of Maduro, the lethal strikes on the narco traffic vessels in the Caribbean, the attack on Iran. I know this about Alexander Hamilton. He did think that the president really should be involved in foreign affairs, like that he recognized. He said, here's an area where that's for him. And you, Michael, worked in a post 9/11 universe where, there was a lot of talk about, have we gone too far? Waterboarding, various things, enhanced interrogation techniques. And so I wonder, and the misuse of the Alien Enemies Act, because the last time it was used was the concentration of Japanese Americans. This is not a great act that Donald Trump is relying on. And normally it means, Alien Enemies Act means you're at war with another country. So Donald Trump's position is, well, we are at war with these countries. They invaded us with their drugs. And the answer is, that's not really what an invasion means. It's not really a declaration of war. So I wonder whether you think that the various, and I think we can even add on to that, the calling out of the National Guards to protect, because that's another example of presidential authority that's being said, I have to do this because I'm the commander in chief. And I need to protect ICE, or I need to protect kids from fentanyl. It's all really connected to the same authority that he claims to have.
Well, you're mixing a lot of things.
I know. We get a lot out this way.
The use of armed forces overseas, I think, is a separate category.
Right.
Jefferson played a little bit fast and loose with that when he went after the Barbary pirates without the authorization of Congress. In fact, he told his fleet to go out and attack them if there was a declaration of war. They attacked without a declaration of war. to which the Barbary then responded with a declaration of war. And Jefferson came back, asked the Congress for authorization to go beyond mere defense without telling them that it had all started because of an unprovoked attack.
But I thought that everyone now agrees that even with the War Powers Resolution, you know what Trump would say is, you want me to go before the country and Congress to ask permission to attack Iran's nuclear facilities? We would have never been able to do it. We don't telegraph what we're doing. If I then go into troops, deployment of troops, that's a war. But if I'm just going to have a strike, that's different. Is there a difference?
Yeah, there's a difference. This actually all started in 1941, before World War II, which, by the way, was the last declared war we fought. And there have been involvements of U.S. forces and with troops on the ground since then, N being a very large number.
You're saying that looked like a war.
Yeah, the
Right.
Korean.
Right.
The Korean
That was
police action
instituted without
a declaration of war.
Right.
It's interesting because Robert Jackson, when he was AG, was asked by FDR whether FDR could order the U.S. Armed Forces to train British flyers in the United States, and he issued a 5-page order. Page 4, to some people's regret, contains the following, what sounds like a throwaway line. Indeed, the President's authority has been recognized as extending to the dispatch of armed forces outside of the United States. Remember, he's being asked about inside. Outside of the United States, either on missions of goodwill or rescue, or for the purpose of protecting American lives or property, or American interests. And that American interest has been used. It was leveraged by later Supreme Court justice who headed OLC. I'm not coming up with the name.
Well, it's Rehnquist and Scalia.
Rehnquist. Yeah, Rehnquist. It's been built out to allow attacks in Libya, Haiti, Somalia, you name it.
Yeah. So I think that there's a difference between the constitutional question, in which generally I am sympathetic to strong presidential power in that area for reasons Thane suggests. You're not going to be able to debate in Congress. I mean, Congress can't pass a law agreeing the sky is blue. Are they really going to be able to authorize an attack? And if they can, could they do it in secrecy? Almost impossible. So there's that constitutional question, but then there's the kind of policy question, which is it wise to do? And it's there that, again, I think that the breakdown and hollowing out of the expertise in the agencies is so important. When I came into the Justice Department, I reviewed General Mukasey's decisions on the state secrets privilege and on the use of force and a bunch of other things. And you'd see an incredible debate in the interagency community, between the intelligence community, the State Department, sometimes Commerce, all sorts of folks weighing in. And it was a robust, real debate. And then you can see why generally good decisions were made.
It's amazing how consistent that theme is up here for you, that you can continue to hammer away at what you saw when you were there, and that kind of back exchange. And the destruction. Can we just do the domestic? Oh, go ahead.
So I thought part of what you were trying to tease out, Thane, and maybe I'm mistaken in seeing this, and that sort of enumeration of the various things that have been done, is that we have been sort of trained, certainly as constitutional law scholars, that there is a difference between the president acting in the theater of foreign affairs versus the president acting.
That's exactly what
domestic.
I was doing.
Okay, that was what you're okay.
Thank you for clarifying what I was doing.
But I think in a world of globalization, it's becoming increasingly difficult to disaggregate what is foreign affairs and what is domestic. I mean, in Neil's case, IEPA is ostensibly a statute that provides domestic emergency powers, but it is being used in the context of leveraging trade questions with other countries. It's being done in the context of foreign affairs. When we talked about, during the election, when we talked about the price of gas and how that related to what was going on in other countries and other economies, like that's ostensibly a domestic issue, but obviously with foreign affairs implications. Like I don't know that sort of facile division between, yes, the president has broad and sweeping powers, no, the president is limited, see Youngstown. I'm not sure that really works in a world where we have an internet, where we have AI, where countries are constantly engaging, and one country's economy and what it's doing has true repercussions somewhere else.
All right, so let's do something domestically that's clearly not foreign. The calling out of the National Guard. Ostensibly, the argument is my ICE officers are trying to implement law enforcement and the immigration laws. That's what they're doing, and the public is interfering. Local police departments don't want to get involved to protect ICE and to protect the public from ICE, or protect ICE from the public. And there are federal buildings that I need to protect. He's saying these are the arguments he's making. And he's saying, yeah, it's true that normally the governors ask for the National Guard, but not in this case because, the governors in Mississippi and Alabama did not ask for the National Guards to integrate Little Rock, Arkansas, or the University of Mississippi. The governors were certainly not interested in that. And Eisenhower, and then was it Johnson, I guess, right? Yeah, Eisenhower and Johnson just said, we're sending in the National Guard for national security reasons. So I'm saying that we do have, and I think you helped clarify what I was trying to say about, we have a kind of ethos now, and that when you hear the word national security, you go, oh, national security. You get the president gets more deference. We defer to him.
Fundamental difference between calling in the National Guard to enforce a unanimous decision by the United States Supreme Court that the schools should be desegregated on the one hand, which is what happened with Eisenhower, and what President Trump is doing, which is saying, I can call the National Guard out because I don't trust these Democratic state governors to enforce the law. It's a part of the root problem is we have a president who thinks he's only governing for part of the country. Up until that point, we've had presidents from both parties who've really understood their job as to be for the entire country. And so it's not surprising once you have that as your vision, that as your mandate, then you go and you start ordering and doing crazy stuff like stuff he's doing with the National Guard. And the Supreme Court, by the way, put a stop to a lot of it.
Speaking
and
of
said,
checks and balances.
Yeah, and did exercise its checks and balances to say no, stop. And it's fortunate that the administration has started to move back on that, but time will tell.
Interestingly, they did that largely, I think, on the basis of an amicus brief.
Right.
Speaking up for writers of amicus
Your
briefs.
colleague, Marty Lederman.
Yes,
Marty Lederman.
a law professor.
Right. Wrote an amicus
Good
brief
people.
pointing out that the statute he was relying on said that it has to be impracticable for to enforce federal law using available force. Somebody pointed out there are about 135,000 federal officers who are authorized to carry weapons. Not to mention that there had been no showing by the administration that they had asked for the normal armed force to solve this problem, and that it hadn't succeeded. So the Supreme Court stopped it cold.
But the whole idea of deploying the National Guard to do domestic law enforcement, leaving aside whether it is actually unconstitutional, it is so against the spirit of the Constitution. And again, it comes back to this whole question of colonial trauma, revolutionary trauma. They had British soldiers living among them. That was part of the colonial experience.
Isn't this the principal essence of the Posse Comitatus Act?
Yeah, we don't want a standing army. They recognize
the military does not enforce local law. We don't want to see military soldiers.
We have to have a military see the Revolutionary War. We can't just do this with sort of atomized militia from different states. We need to have a centralized military, but we understand that a strong military presence can easily tip over into tyranny.
It says, though, the Posse Comitatus says absent specific congressional authority. And if there's a piece of good news here, I'm groping for good news, he has not invoked something called the Insurrection Act.
Right.
Yet.
Yet.
Well, he clearly doesn't have any of the facts, but at this point, would it even matter?
It's a very dangerous statute.
By the way, when you heard Posse Comitatus, it is Latin, but I know I tell this people all the time. When you watch 20th century John Ford movies, and the sheriff always goes, let's round up a posse. It actually comes from that. I mean, really, the idea that local law enforcement is the job of the people who are there. And if we need you to help out, we're going to deputize you as part of the posse. And so, because the military doesn't do that, local police powers do that. Can I just go back a little to the foreign affairs piece of this? Because Maduro is clearly the kidnapping of a foreign leader and his wife. Some of these strikes that we've seen, the narco ships, the argument is, again, invasion, a national emergency, fentanyl, cocaine. But I continue to come back to this, and it's because two of you clerked on the Supreme Court, and you were the chief federal cop. Barack Obama, who is the darling of the progressive left and the Democratic Party, ordered the assassination of an American citizen whose father is still pissed off about it. I think he's still alive. Anwar al-Awlaki was the Muslim cleric in Yemen who was the one who radicalized Major Hassan in Fort Hood. And every young jihadist was listening to this American who was born here, who is making these YouTube videos and driving and literally radicalizing.
He also got a bonus in that drone strike. The publisher of a magazine.
I didn't know that. Really?
Yeah,
he got two.
Publisher of a magazine that included articles like "How to Build a Bomb in the Kitchen of Your Mom."
That's also in YouTube, right? There was a video how to make a bomb.
He got the two of them with the same.
Yeah. So anyway, that he was an American citizen, and I'm wondering whether we have moral and legal consistency when we say, I don't think anyone seemed to be very upset.
I think it's really dangerous to both sides this. I mean, there's a fundamental difference between going and attacking someone whom the intelligence community deemed a terrorist and a threat, and what's happening here with these narcotics boats in which people who are, they're trying to hold on to the raft for their lives, and the order is no quarter, kill them. And which is a straightforward violation of international law and the laws of war and the Geneva Conventions. There are, I'm not here to defend the drone strikes program by any means, but it does seem really different than what we have here, which is, international law says something, who cares, blow it off.
Well, and also if you're a member of PETA, I don't mean this jokingly, Obama killed a lot of goats with the drone programs. And it's just one of those things, people, you hear them say this, that no one actually wants to talk about how many animals were killed in the drone strikes. That's just, but again, it does seem to be, yes, it's not a whataboutism, but it does seem that nobody questioned the assassination, but you're going to say, of course, Osama bin Laden, of course, that didn't require anything other than just Geronimo. We got Geronimo. Let me just ask a question from the audience, and then we're going to say goodbye to Neil, and then I want to end with something Melissa just wrote a law review article that's coming out in the Northwestern Law Review with two of her colleagues that raises some interesting question about the lawsuits that you're seeing, the settlements against CBS News, the settlements with some of the law firms, I don't want to use the word shaking down, but it sounds like the shaking down of universities.
Go ahead.
Well, this audience will like the word shaking down, but you could just say, well, the efforts to bring Title VI actions against universities, to overhaul the admissions program, to dispense with DEI programs, to dispense with transgender women playing sports, and to protect Jewish students on campus. Those various things fall under and the shadow docket, right? Of course, these are all legal maneuvers that the president has been using. So let me just start with a question, because you clerked on the Supreme Court, and clearly Michael knows this. This is a good question. Most people don't know. Why do you think SCOTUS takes so long to render decisions? And most people don't realize the vast majority of decisions especially the big cases, don't get decided until right before July 4th every year. What's happening tonight is weird. On a major case, he's got to run home because we're going to hear the case tomorrow morning. That's weird. Normally, this would have been July 4th, right?
Yeah. So what happens is you have, first of all, briefing done by both sides, and then you have an oral argument. And then the justices go back and a day or so later vote. They sit around on a conference table and they begin by shaking each other's hands. It is an incredibly civil group of 9. Nobody can speak twice until everyone's spoken once, and they take a tentative vote. And at that point, they'll then write a draft decision. And then if there's a dissent, a draft dissent. The draft dissent will be circulated to everyone. And then
the clerks are reading it
everyone's reading it. And then they might change the majority opinion to account for the dissent. And then the dissent will say, oh, we're going to change it to respond to the new majority. And this can go back and forth many times. And sometimes what happens is a justice might change their mind from their initial vote. And so you can lose a majority that you might have had. And sometimes that's why things take so long.
But doesn't that play into what Melissa's about to talk about, which is the shadow docket? Because the shadow docket doesn't get any of that.
I'm sure she will.
Right.
And good luck.
Thank you.
Wonderful to see you all.
Good luck for tomorrow, buddy. I'll see you. Neil Katyal. Tomorrow, 10:30. You were there. You saw the guy. Let's wish him best luck. Travel safely, buddy. Yes, this is a good time for you, Melissa, because you wrote an article that's coming out in the Northwestern Law Review in which you said, forget the unitary executive theory about this power over independent agencies and executive order in the executive branch. Forget about the encroachment on Congress, which is the way we normally think about it. What about the encroachment on the courts through lawsuits, settlements, shadow dockets, that we're forgetting that this is its own representation of expansion of authority?
No, so thank you for asking. So first, the unitary executive theory, which I think most of us have heard about at this point, is just this idea, like kind of cooked up in the 1980s, that the entire power of the executive branch, all of the agencies, is lodged in the body of the president, in the office of the president. And there are lots of people who agree with it. There are equal numbers of people who disagree with it. But it has been a sort of prevailing doctrine, and one that I think has animated this president in particular, but I don't think it's the only thing that's animating him. We have been conditioned, and I think in constitutional law, we've been conditioned to think about the whole question of separation of powers as the sort of paradigmatic struggle between the president on the one hand and Congress on the other, and the idea that the president sort of taking legislative power from Congress. That's the traditional model, like Youngstown, sheet and tube versus Sawyer. We are arguing, my co-authors, Leah Littman and Kate Shaw and I, in this paper, that that traditional model no longer holds sway, not for this president. This president is not content to deal with the conventional narrative of simply encroaching on the legislature and occupying the entire executive. He's now doing things to encroach on the authority of the judicial branch to, as John Marshall said in Marbury versus Madison, emphatically say what the law is. And he does this in a particular way. So there are the lawsuits that have been filed against various media institutions. They are usually meritless. I think if anyone was giving you advice about whether to file them, they would say, no, you can't win this. It doesn't matter, though, if he wins. He wants to provoke a settlement and bring these institutions, which are also accountability institutions, to heel. He wants to silence dissent. He wants to bring his critics to heel. And they do it very well. Those lawsuits do it very well. And when they do it, and these settlements are brokered, they're not private settlements in the way that you normally have between, a company for widgets and another company for widgets.
In fact, isn't that one of the difficulties with settlements, that people say settlements are secret?
These are not secret.
These are not secret.
One of them is the president of the United States. I mean, he's suing in his ostensibly private capacity, but he's doing so in a way that accrues power to his official position. And when these settlements are made public, everyone knows. So everyone now knows that, CBS cut an interview with Kamala Harris the wrong way, whether or not that has actually been adjudicated to be the case. The executive orders against the law firms and the university do a different kind of thing. So they're not necessarily operating in the lane of traditional litigation. I would argue they're actually creating a shadow system of legal process that is entirely exogenous to the traditional legal system. So when the president drafts an executive order against a law firm, for example, he's enumerating a set of grievances. And these grievances could be things like, you represented poor people. You represented immigrants pro bono. You have a DEI program that brings in associates from all different backgrounds.
Doesn't he also, part of it is that you hired the wrong people that attacked me. Isn't it just
all of those things?
We've had Andrew Weissman on this stage. You and I were together, and he's a colleague of yours. And I think he shows up in one of these lawsuits.
He does. He shows up in the Jenner and Block lawsuit, in the Jenner and Block executive order. He's enumerating particular grievances, and then when the law firms capitulate, when they settle, those grievances become concretized as actual misconduct. And then what was really kind of wild about all of this was the first spate of executive orders. Very few law firms challenged them, and more importantly, more law firms preemptively settled, like went to him hat in hand, like, we don't want this heat, we'll settle with you in advance. And they voluntarily relinquished their DEI programs, voluntarily changed who they were representing.
Did they sign anything that says, yes, we did in fact do these things?
We don't know, because this is all made up. Like, we don't know. Like, they're quote unquote settlements, quote unquote deals. But they concretize the idea that DEI is unlawful, even though no court has said that that is the case. They concretize the idea that it is somehow misconduct to represent certain groups of people, even though we have a constitutional right for people to be represented in various contexts. So again, he is using this sort of ersatz legal process to articulate his particular vision of the law and make it so, and in doing so circumvents the court's authority to do that. And we're not talking about it. We're talking about whether Paul Weiss capitulated and whether this firm capitulated. We're not talking about what is actually being done. We have a new way of making law and making it final, and it is entirely outside of courts.
But it is similar to what Neil just left, but his case for tomorrow, the Tariffs, the International Economic Emergency or Emergency Economic Powers Act, using a law in a way that it's never been used before. Alien Enemies Act, right? In order to send out the Venezuelan gang members, allegedly, we're using that. And the DEI thing, I think, just to be clear, I think they think that when the Supreme Court invalidated affirmative action programs, that they think broadly that's the same thing. That when they got rid of affirmative action, that means you can't use the word diversity because that is affirmative action. And again, that's not what the Supreme Court said, but I think that he is pointing to something, but he continues to do the same thing. He points to something and misapplies it.
But it's dangerous in two other ways, actually. One is it exercises a kind of peripheral pressure even on parties who are not involved in the lawsuit.
Exactly.
It's a warning shot, not only to the firms that are directly involved, but also to others that are not at all involved, that they best keep a low profile. Second problem with it is, at times, the litigation is against companies that are regulated by the federal government, which he heads.
No, I mean, this is the point. I mean, he's ostensibly filing these in his private capacity, but he's the president.
Right.
And they know that the partners will just come together and say, we don't want this headache. We're going to lose business.
Yeah, I mean, it's not simply we. It's our clients.
Our clients, right? Our clients don't want to.
Which is part of the.
In fact,
part of the problem.
Not only did Neil want to leave because he had to catch a flight, he wanted to leave because of this question. He didn't want to be here because he works for a law firm, and so he didn't want to be in this discussion for that reason. I don't want to be part. I don't want the clients to see me sitting on the stage of the 92nd Street Y saying that the clients shouldn't care about these things. But let's take one more question from the audience and say goodnight to Melissa and Michael. Thank you so much for joining us. This was really wonderful, really entertaining, smart. We should thank you. Some of you know this. We have a tradition at Folks at 92nd Street Y. Melissa was with us last year. I'm not sure what we're doing this year, but on July 8th, you can't buy tickets yet, but we have something that's become wildly popular. I think we're on our 10th year, called Law of the Land, the Supreme Court's year in review. And we have like 2 law professors and we have 2 journalists who cover the court. And we, in common language, not for lawyers, for the general audience, we explain what the court did this year. And it's become wildly popular online. So it's July 8th. Just remember, you can't buy tickets yet. It's not been posted, but you'll see it tends to be one of our more popular programs. Here's something that just, again, generally speaking, the people ask this question all the time. Would this fix things? Should the Supreme Court be expanded to 13 seats with staggered terms? You have very familiar feelings about the court. things have changed in the court. Like, for instance, when I had Sonia Sotomayor on this stage a number of years ago, and I said, you originally said when you clerked for her, for God's sakes, right? When she was a appellate judge, she said, you used to say we think we should have cameras in the courtroom, and then when you became a Supreme Court judge, you changed your mind. And she said, yes, I did. She said, and she's tried to explain to the 92Y audience and Y audience why she changed her mind. But COVID changed things again, because COVID opened up the court. All of a sudden, you could listen to the oral argument in a way online, and it humanized the court in a way that before that we didn't. So here's another possibility of a change. The Supreme Court wasn't always 9 members. Should there be lifetime appointments, and should there be staggered terms? What do you think, Michael?
Yes and no. Yes to the lifetime appointments, no to the staggered terms.
You like it the way it is?
Yeah.
So I actually think I've changed my mind about this. I wrote a piece in the New York Times, probably 2016 maybe, arguing against term limits. And I think I've changed my mind about that. We are an outlier among constitutional republics in terms of how we structure our court. We are obviously a model in a lot of ways, but most constitutional courts now have term limits for their members. And I think that's probably a good thing. And I think staggering the terms so that presidents all have an opportunity to appoint someone to the court would be a way to bring down the temperature on some of these appointments, so every appointment doesn't feel like
so loaded.
Yeah, this is the end of the world if
Right.
so and so is appointed to the
Or
court.
please resign now before it's too late.
Well, I mean, right now, our podcast is talking about it incessantly. Justice Alito has announced his new book, So Ordered. The book tour starts on October 6th, but the Supreme Court's term starts on October 5th. How's he going to promote the book if he's on the court? Maybe he's not going to be on the court, right? So it seems like a retirement is in the offing.
Palace entry.
It is, and just like, who's going to be and what's going to happen. And I think it just like we could completely dial it down a little bit if we did sort of have these staggered terms, limited people. And again, it would be nice, I think, just to have fresh blood in the office at different times.
Michael, I'll give you the last word. William Douglas, over 50 years on the court. Is that how many years was he on?
I didn't keep track.
I mean, 20 years is considered a small term, right? Pretty small. And 20 years seems like a long term. The staggering, I'm sure, is at least below 20, I think. So you're of the view that, the longer you sit on the court, it's not just the tradition, but there is value in having that perspective. You are a former federal judge, so you can offer this perspective.
Yeah, I had colleagues one colleague who served until the age of 98, and who took on new cases when he was in his 90s. When lawyers asked for more time, his response was, I haven't got more time.
Is this Judge Pollack?
Yeah, Milton Pollack. Right. That's very much the exception. I think that staggered terms and term limits wouldn't lower the pressure, it would raise the pressure. It would also raise the perception, which I find very uncomfortable, that because you're appointed by a particular president, you're appointed to do it a particular way and to come out a particular way. Ask Dwight Eisenhower about the appointments that he made. Ask about Justice Souter. Ask about a lot of people who have changed their...
O'Connor, Kennedy, right? A number of people who ended up breaking the hearts of the presidents that appointed them, because
to the extent those presidents had hearts,
right?
which is debate for another evening. But yes, I think it's important to keep that in place.
That is a great way to end tonight. Melissa Murray, Michael Mukasey, thank you all. Keep coming back to the 92 NY.